You have been referred to the interpretation of the jurisdiction of the Supreme Court, specifically Articles 163, 4, A and B, which talk about application and interpretation, matters of public importance, and of course, not forgetting the principal function found at Article 140, which is on the elections of the president. I'm sure you're familiar with the decisions in Munya 1 and Munya 2. Yes. And in Munya 1, which was the first case that dealt with the question of application and interpretation, the court assumed jurisdiction over an election. And the court held or found that the Elections Act was a normative derivative of the Constitution. So it was just general application. And the court then traced the application from the High Court to the Court of Appeal and then found jurisdiction. Now, are you that judge who will diminish the jurisdiction that the Supreme Court has defined for itself? Would you come to court and seek to create new parameters for the Supreme Court?
First and foremost, I alone cannot do any of those things. We're a bench of 7 judges, and through collegiate discussions and appropriate dialogue, the court will come to those conclusions. But
let me rephrase my question. Do you agree with the decision of the Supreme Court in Munya 2 and Munya 1?
Good. That helps me focus the question better. I'm a little biased because I was on the bench of the Munya decision. The Court of Appeal's decision in Munya is actually my decision. So I'm a little biased. So it'll be very easy for me.
Judge, I was the lead counsel in the Munya decisions.
That's right. So it'll be very easy for me to say that I don't agree with the Supreme Court, because I can't disagree with the Court of Appeal. So yes, I have personally had concerns about the decision. And I have personally had concerns about the dichotomy of reasoning in that case as against the earlier cases where the Supreme Court decided on jurisdiction. And I go back to Goge and Caparo and the KCB and Macharia and those cases, where the Supreme Court itself laid down the rule of interpretation and said not anything and everything that touches on the interpretation or the application of the Constitution will fall for our jurisdiction, will come before us. There must be an important constitutional moment. I think those are the words they used, that it must be so important and of a jurisprudential moment. It should be a subject of jurisprudential moment to invite our jurisdiction. And so my understanding from those earlier cases was that the Supreme Court was defining its own jurisdiction in a more restrictive way, not open to just anything and everything. So it came a bit as a shock, even to me, that now they're saying, no, but this involves interpretation and application of the Constitution, so we're going to invite Munya to come to our court. And seized the opportunity to rule on that case from citing it as being interpretive or having an application of the Constitution. And personally, my personal opinion, with much respect and humility, is that the court expanded its jurisdiction needlessly and unnecessarily at this point in time. And I think it gets worse. Do you want to continue with that conversation?
Yes,
Yes, in fact, I'm now worried because you just, a few moments ago, Judge, you just described yourself as a progressive judge, that you're a transformative judge.
Yes.
So if you are the kind of judge who would stick to the law, Article 163(4)(a) talks about application and interpretation of the Constitution. What do you understand by application of the Constitution? And are you by extension then saying that all the decisions where the Supreme Court assumed jurisdiction in matters concerning elections, in your view, did not apply the Constitution?
Well,
and therefore, by extension, what you're saying is that even under 163(4)(b), that election of governors of this country are not matters of public importance, that there are no issues of public importance that emerge from those elections. And then as you answer that question, Judge, I want you to consider one question. You sat in the Wambui decision.
Yes.
On time.
Yes.
Again, the Court of Appeal was wrong. If the Supreme Court had not intervened, what kind of jurisprudence would you have left this country with on the question of time, entertaining appeals which were nullity ab initio? Let me understand that, or petitions that were filed out of time. Where do Kenyans go where the Court of Appeal is wrong, if the Court of Appeal is opposed to the expanded jurisdiction of the Supreme Court?
All right, let me try and answer that in two different ways. First and foremost, the Mary Wambui case, your question is, if the court was wrong, the Court of Appeal was wrong as it was in this case, where would it have gone if it was not for the Supreme Court? Let me invite you to consider that even the Supreme Court went beyond the boundaries of its own jurisdiction in entertaining the Wambui case. This is why I say so. I began by saying that the Supreme Court's jurisdiction is limited to the 4 areas of the law that are provided in Article 163. And the Supreme Court itself has said, when dealing with Section 14 of the Judicial Services Act, which invited them to open cases in respect of judges who had been removed from the judiciary and removed on account of things they did wrong with particular cases. Section 14 invited them to have jurisdiction to reopen those cases coming from the Court of Appeal. And what was the answer? The answer was that our jurisdiction is limited to these 4 areas. Nobody can craft new jurisdiction, not even Parliament. That Section 14 is completely void, ab initio. If that is the position, we're talking about stare decisis now. If that is the position that the Supreme Court took, where did they, I ask, where did they get the jurisdiction in the Mary Wambui case? Because the issue of time, whether the petition was filed in 28 days or not, was not an issue before the Court of Appeal. It was not an issue before the High Court. So, the Supreme Court crafted original jurisdiction to entertain Wambui. That is my position.
Application
on that question
of the Constitution.
No, Commissioner Agenda, can you give an opportunity to
Yes,
AG to
Judge, you gave us a teaser there, and I think we have lost it. You said it got worse. Could you please make that sentence complete? What got worse and how?
Assuming jurisdiction in the Mary Wambui case, I mean, that words came from Professor Agenda. What I wanted to say, he said it, and he cited the case of Mary Wambui. And that's the worst part I'm talking about, that this jurisdiction issue got a little too contrived when we arrived there.
Commissioner Wasame, as I want to interject. But just before you go on, I would like Commissioner Agenda to leave cases where he was an attorney. especially one for Munya. Please use other examples. Let's move on there. Commissioner Wasame?
Judge,